Hi, and welcome back to a special criminal justice episode of InstaVision. I'm Glenn Reynolds, and I'm joined today by Marc Levin. No, not that Marc Levin, the other Marc Levin. He's the director of the Center for Effective Justice at the Texas Public Policy Foundation, where they've launched the Right on Crime initiative. Welcome.
Well, thank you for having me.
So with all the publicity over things like the Aaron Swartz case, we've had people recognizing that we've kind of got an over-criminalization problem. But does it go beyond internet superstars?
Oh, absolutely. Well, nationally at the federal level, there's over 4,500 federal offenses. In Texas, over 1,700 offenses. Arizona, we looked at over 1,400, over 4,000 offenses. So there's so many crimes, and almost all of them are outside of the penal code in the various states. So there are things dealing with ordinary business activities. Here in Texas, we have 11 felonies alone relating to harvesting oysters. So these are things no one would have thought were criminal, and yet you can go to jail for them.
Yeah, well, that's actually sort of a point I made in a recent article of my own. The common law used to actually sort of pay attention to the distinction between malum in se, that is, things that were evil in themselves, like rape or robbery or murder, and things that were malum prohibitum, things that were only wrong because they're forbidden. Nowadays, almost all the crimes we've got are malum prohibitum, and there's no like intuitive sense as to whether something ought to be a crime or not when you're harvesting oysters. Is it absurd now to maintain this legal fiction that, you know, a citizen is presumed to know the law?
Well, I think you hit on an excellent point, and a perfect example of these regulatory offenses we're talking about. In Texas, for example, it's a crime to mislabel fruit, but there's not an element of that offense that says anyone has to be harmed by it. There is no victim. The victim is supposedly the government, which is, we've turned criminal law on its head. It's supposed to be to prevent me from harming you. And so, Ed Meese has recently suggested in a law review article that we have a ignorance, a mistake of law defense, because, you know, the old saying is ignorance is not an excuse. And that makes perfect sense when the crimes are simply murder, rape, the traditional things that kind of parallel the Ten Commandments. But now we've expanded it to so many areas where essentially crime is being used to regulate economic activities that are actually totally legal in general, but somebody didn't file the right paperwork or mislabeled something or what have you. And so you cannot presume that people would be aware of all those things. In fact, there's so many criminal laws, including, by the way, statutes that say agencies, regulatory agencies, can designate violations of their rules as a criminal offense, and they meet every week. No one can keep up with it. So now we do need to, as Ed Meese proposed, this mistake of law defense would be cabined, where people would have to have it has to be reasonable that they would have not been clear that something was against the law, and they wouldn't have to know, what chapter and verse. But, we all generally know theft is against the law, rape and murder. So this can be done in a cabined way that still, doesn't interfere with what we really want police and prosecutors to focus on, the kind of crimes that hurt you and me.
Yeah, it's funny because when police break the law, they often have a defense of good faith immunity where they can, in fact, get off the hook by saying, I didn't know it was illegal. No reasonable person could be expected to know it's illegal. Ordinary citizens whose jobs don't deal with the law and enforcing the law all the time have no such defense. And that seems to me to be quite unfair, if not actually unconstitutional.
Well, that's a great point. You're absolutely right that, in cases where someone's trying to collect damages, like a citizen who was wrongly imprisoned, they would have to show that law enforcement or a prosecutor knew the law and intentionally disregarded the law. And it's a very high hurdle to climb. But then the flip side is, for you and me, we're having this growth in strict criminal liability offenses, where even with no level of intent, and so I'll give an example. In Florida, Right on Crime actually filed an amicus brief, along with a number of other organizations, arguing against that their drug law, which says it's strict criminal liability, no culpable mental state required for conviction, that violates due process, unconstitutional, and that was held to be the case by a federal judge appointed by Bush, and it's now on appeal to the 11th Circuit. And so I'll just give you an example. If you rented a car from Hertz and there were drugs where the spare tire was supposed to be in that compartment, which not only did you not know there were not drugs there, you weren't even negligent. Who would check the spare tire compartment when they rented the car to see if there were drugs or a spare tire? And so yet you would be under strict criminal liability. You possess the drugs, end of story. And, Florida mandatory minimums, you could be going to prison for a long time. So and in the broader sense, a lot of the offenses relating to these business activities, they're also dispensing with strict criminal liability. So one of the things we want to do as law lot of times the legislature simply doesn't think to provide a culpable mental state, so the statute is silent. So we're asking states to adopt some model legislation that would provide for a default mens rea, a default culpable mental state that would kick in when the statute is silent as to whether intent is an element of the offense.
So as part of the problem that prosecutors often like to pile on a lot of these kinds of crimes is, as part of overcharging to induce a plea bargain, they'll put on a lot of these kind of things, maybe with a potential sentence of 50 years. All they're really looking for is a plea bargain with 6 months in jail or maybe even just a big fine to help their conviction rate. But they want to make the stakes high enough that you don't dare not plead guilty.
Oh, yeah, that does occur. And I think the way to address that is to try to eliminate some of these overlapping criminal laws where the same conduct is criminalized by numerous different laws. And so states need to, and the federal government, of course, review all their crimes and really streamline their codes. I think the other problem is just the sheer overbroadness overbreadth of many of these statutes. Many of them are vague, and so that also essentially gives prosecutors tremendous power. There was the head of the Soviet police once said, "Bring me the man, I'll find the crime." And so essentially, if almost everything is a crime, you mean that gives total discretion to prosecutors both to decide who to charge and then to pile on a virtually unlimited number of different offenses in the same charge.
Yeah, that's exactly right. I mean, it's funny, you get all this due process where the police are investigating you. Then if you go to trial, there's all this due process for the trial, but the actual part where most of the action happens, which is when they decide whether to charge you and with what, and then negotiate a plea bargain in the middle, there's basically total discretion for the prosecution in that middle phase, and almost no due process governing that at all.
Well, that's certainly true. And of course, we know most cases are resolved by plea bargains. And I undoubtedly think there's some people that plead guilty just to avoid the possibility of, potentially draconian sentence. But I think it's one of the things we've advocated is restorative justice. And so this goes back to more of those things that should actually be criminal, like, if an 8-year-old in my neighborhood steals something out of my garage, okay, why don't we sit down and have a binding agreement for restitution and community service? And the only way it goes to prosecution is if he doesn't meet that agreement. Now, that we just streamlined, we got rid of a lot of excess government right there. We didn't need the courts, we didn't need a prosecutor's office. And as a victim, what I wanted was restitution, that kid to learn a lesson, an apology, which you can only get through a face-to-face victim offender conferencing or mediation, and for him to provide some service and learn something from it. So, I think we could take a number of cases out of this overly bureaucratic prosecutorial system that we have and allow victims to opt out of it and reach an agreement with the offender.
Well, I'd certainly like to see something like that. Last question. Where can viewers go to find out more?
Well, thank you. And thank you for the great work you've done on this. It's rightoncrime.com. And we've got many resources, not only articles, but videos, testimonials, examples of states where we've actually been able to enact some of these ideas that we've been talking about today.
Well, thanks so much for taking the time to talk with us.
Well, thank you.
That was Marc Levin, Director of the Center for Effective Justice at the Texas Public Policy Foundation and head of its Right on Crime initiative, which you can check out at rightoncrime.com. Thanks so much for tuning in. We'll be back soon. In the meantime, have fun on the internet. Thanks.